My name is Miriam Calloway. I'm 38. 4 years ago, my brother and his wife filed paperwork that transferred my childhood home, the house my father built with his own hands over 2 summers in 1987, into their names alone. They did it while I was sitting in a hospital room holding my father's hand through his second round of chemotherapy. They used a document they told me was a routine care authorization. I had signed it in a hallway, in 30 seconds, with a pen my sister-in-law handed me. What they didn't know, what they couldn't have known, was that 6 weeks earlier, my father had called me into his study and handed me a second copy of the original property deed. He told me to keep it somewhere safe and to never mention it to Daniel. I didn't know why he said that then. I do now. The morning my brother stood in the kitchen of that house and told me I had 30 days to remove my belongings, the morning he actually smiled when he said it, I looked at him for a long moment. I didn't cry. I didn't raise my voice. I said, I'll need to make a phone call first. Before I tell you what happened on that phone call, like and subscribe the channel, and tell us in comment from where you are watching this video, and let me take you back to the beginning. Because the beginning matters. You need to understand what that house was before you can understand what it meant to take it. I want to start with the smell. That is always where I start when I think about that house, the particular smell of the front hallway on a summer morning, which was cut grass and wood polish, and something underneath both of those things, something older and warmer that I have never been able to name. My father used to say that houses don't just hold furniture, they hold time. He wasn't a poetic man by nature. He was a plumber by trade, a Baptist by upbringing, and a deeply stubborn person by disposition. But he meant that literally. He believed the walls of a house absorbed everything that happened inside them, arguments and Sunday dinners, and the particular silence of very early mornings. He believed all of it stayed. I believed him, I still do. The house on Delancey Street in Savannah, Georgia was built in 1987 by my father, Curtis Calloway, over 2 consecutive summers. He did not hire a contractor. He did not cut corners. He learned what he needed to learn from books and from a retired carpenter named Earl Whitfield who lived 3 streets over and who came by most evenings to check the work and drink sweet tea on the unfinished porch. My father was 34 years old that first summer. My mother, Patricia, was 31. My brother Daniel was 9. I was not yet born. By the time I arrived, in 1986, my mother will correct me here, she always does. She would say 1987, January, 2 weeks before the foundation was poured. The house was already a project with a heartbeat. My earliest memory is of sawdust, the specific quality of light through plastic sheeting over an unfinished window frame. My mother holding me on her hip and pointing at something my father was doing with a level, explaining it to me in the voice she used for things she thought mattered. The house had 4 bedrooms, a wide kitchen, a porch that wrapped around 3 sides, and a study my father built into the back corner with bookshelves floor to ceiling on 2 walls. He read constantly, history, mostly, and technical manuals, and occasionally mystery novels that he kept spine inward on the shelf as though slightly embarrassed by them. The study smelled of him in a way no other room did. After he died, I would sometimes go in and just stand there. We were not a wealthy family. We were not a struggling one either. My father's plumbing business, Calloway & Sons, a name he had chosen optimistically before Daniel made clear in adolescence that plumbing was not his ambition, provided a steady if unspectacular living. My mother worked as a school administrator for 31 years. We took 1 vacation per year, always driving distance, always somewhere with water. We ate dinner together every night. My parents did not argue in front of us. Or if they did, it was the kind of arguing that looked more like negotiation, calm and practical and over quickly. I am telling you all of this because I need you to understand what that house was not. It was not a symbol. It was not an asset. It was not, in any ledger my father kept, an item to be assessed or allocated or disputed. It was the place where my mother had stood at the kitchen window every morning of her adult life. It was where my father had built his bookshelves and his study and his particular version of a good life. It was, in the plainest sense I can put it to you, home. I trained as a nurse in Savannah, graduated from Armstrong State in 2009, and took a position at Memorial Health University Medical Center where I have worked ever since. I chose to stay in Savannah partly for the job, partly because the city suited me, the humidity, the live oaks, the pace of it, and partly, if I'm being fully honest, because I had never felt any particular pull to leave. My friends were here. My parents were here. The house on Delancey Street was 12 minutes from my apartment. Daniel had left Savannah at 22 and not looked back. He had gone to Atlanta for a business degree, met a woman named Constance Webb in his second year, married her at 26 in a ceremony my parents drove 4 hours to attend, and settled in a suburb of Atlanta called Alpharetta, where he sold commercial real estate and drove a car that was slightly too large for his driveway. He was successful, in the way that the word successful is often used to mean acquiring more than you strictly need. He called my parents on Sundays. He visited at Thanksgiving and occasionally at Christmas. He sent thoughtful gifts and remembered birthdays. I am describing him this way not to be uncharitable, but to be precise. The Daniel I grew up with, the one who had taught me to ride a bike on that same Delancey Street, who had covered for me once when I stayed out past curfew at 16, who had danced with our mother at his own wedding in a way that made everyone in the room soft, that Daniel was not a villain. He was a decent, somewhat distant older brother who had built a life elsewhere and maintained our family connection with dutiful regularity. The Constance variable is where the story begins to shift. I did not dislike Constance at first. I want to be careful here because it would be easy and wrong to flatten her into a cartoon of herself from the beginning. She was smart and organized and funny in a dry, observational way that I found genuinely entertaining at first. She had opinions about everything and the confidence to share them unsolicited, which could be either refreshing or exhausting depending on the topic. She and Daniel seemed well matched, both of them contained, practical, ambitious. They did not have children, which was their business and no one else's. What I noticed over time was something subtler, a quality of attention she brought to certain conversations, a kind of focused listening that only switched on when the topic turned to specific things. The house, my father's health, what my parents' plans were long-term, whether they'd had any conversations with an attorney, whether the deed was in both names or just my father's. These were not unusual questions, necessarily. People think about these things. People ask about them. But there was a texture to the way Constance asked them that I could not quite name for years. Something that felt less like curiosity and more like assessment. My father, for his part, was pleasant with her and slightly formal. Not cold, just correct, the way he might be with a colleague he respected but had not chosen. My mother was warmer. My mother was warm with everyone. I was 28 years old the first Thanksgiving I noticed Constance's eyes moving around the kitchen while my mother cooked, cataloging the space with an expression I would not be able to identify for another decade. At the time, I filed it away without a label. I am a nurse. I notice things. I don't always know immediately what I'm noticing. I know now. My father did not get sick until he was 67. For most of my adult life, he was simply and completely himself, a large, deliberate man who moved through the world at his own pace and expected the world to accommodate it. He had retired from active plumbing at 62, handed the business to a former apprentice named George Tillman in an arrangement that gave him a modest ongoing income and complete freedom from early mornings. He spent his retirement reading and gardening and driving my mother to her book club on Thursday evenings, and arguing cheerfully with the men at his church about questions of biblical interpretation that none of them would resolve in their lifetimes. He was, in short, happy, a specifically and uncomplicatedly happy older man. I did not take that for granted. I watched other people's parents at the hospital, the fear in them, the loneliness, the specific grief of outliving purpose, and I looked at my father pottering in his garden and felt something close to relief on his behalf. The Thursday he called me to tell me the oncologist had found something, I was at the end of a 12-hour shift. It was October. I remember the light in the parking garage, orange and flat. I remember sitting in my car for a long time after we hung up without turning the key. Non-Hodgkin lymphoma, diagnosed at stage 2. Treatable, the oncologist said, and she was right, it proved to be. He went through 6 months of chemotherapy starting in January and came out the other side diminished in some physical ways but fundamentally himself. Still reading, still gardening, still arguing about Deuteronomy on Sunday mornings. But something had shifted in him. I noticed it first in small things, a hesitation before he answered questions he would previously have answered without pause. A new habit of going into his study alone in the early evening and closing the door. He had always been a private man but not a secretive one, and this felt different. Like a man who had acquired information, he was still deciding what to do with. Daniel and Constance came down from Alpharetta twice during the treatment period. The first visit was in February, 3 weeks into chemotherapy, and it was attentive and appropriate. They brought food, they sat with my father. Constance organized his medication schedule on a printed calendar she taped to the refrigerator. It was thoughtful. My mother was grateful, I was grateful. The second visit was in April, and it had a different quality. I arrived at the house on a Saturday morning to find Daniel and my father at the kitchen table with what I initially took to be insurance paperwork. A thick folder, multiple documents, pens out. Constance was standing at the counter making coffee with her back to the room, and the particular stillness of someone who has positioned themselves carefully. My father looked up when I came in and something crossed his face. I would call it discomfort, though that is not quite right. More like the expression of a man who had been mid-conversation and was recalibrating. "What's all this?" I asked. In the tone I used for questions, I already suspected the answer to. "Estate planning," Daniel said. He said it easily, the way people say things they've rehearsed. "Dad wants to get things organized, it makes sense." My father said nothing. He looked at the table. "Dad," I said. "Your brother's right," he said. "It makes sense to have things clear." I looked at Constance's back. She did not turn around. She poured the coffee. I sat down. I asked what kind of organizing they were doing. Daniel explained trust documents. He said, consolidating things, making sure everything was in order before, and then he stopped, as though the sentence had somewhere he didn't want it to go. "Before what?" I said. "Before anything happens," he said. "It's just practical." My father still had not looked at me. I stayed for the rest of the morning. I watched Daniel explain documents, and my father sign them and Constance witness, and I told myself it was practical. It was sensible, people do this. I told myself I was being suspicious for no reason. I told myself a lot of things that Saturday morning that I would spend the next 4 years untelling myself. What I did not do, and I have lived with this, was ask to read the documents before my father signed them. He was alive, he had capacity. He was a grown man making his own decisions with his adult son. I had no basis to intervene. I told myself that. I still do. The erosion doesn't happen all at once. I want to be very specific about this, because I think it is the part people most often misunderstand from the outside, the way betrayal of this kind moves. It is not a single rupture. It is a tide. It comes in by degrees, and each degree seems manageable, explicable, maybe even reasonable, and it is only when you look back from the shore that you can see how far it took you. The small wrongs started in the summer, after my father's treatment ended. Constance began calling the house more often. This was not by itself wrong. My father had been ill, she was being attentive. But the calls had a pattern I noticed when I happened to be visiting. She would call in the evenings when my mother was at her Thursday book club, or on Saturday mornings when my mother was at her garden club. She called, in other words, when my father was likely to be alone. I am a nurse. I am not naturally suspicious of people's care schedules, but I notice patterns. My father mentioned, in a careful, offhand way, that Constance had been helping him review some financial documents. He used the word helping. He said it with a flatness that told me he had chosen it deliberately and moved on before I could ask what he meant. In September, Daniel called me to say they were thinking of formalizing the property arrangement to make things easier for everyone. I asked what that meant. He said it was just housekeeping. Since Constance had some real estate expertise, they thought it might make sense for her to be listed as a co-manager of the property for administrative purposes. I said I didn't understand why that was necessary. He said it was just a formality. He said it twice. I said I wanted to talk to Dad about it first. He said of course, naturally, they weren't doing anything without talking to everyone. I went to see my father the following week. I sat in the kitchen with him over coffee, and I asked him, carefully, whether he'd had any conversations with Daniel about the house. He looked at me for a long moment. He had the eyes of a man who was choosing between two true things and was not sure which one to say. "Your brother has ideas," he said finally. "What kind of ideas?" "He wants things to be organized." He paused. "Constance has been helpful." "Helpful how, Dad?" He looked at his coffee cup. "She understands these things. Property, how it works. I don't always understand the paperwork." Something tightened in my chest. My father was not a man who admitted to not understanding things. He had built a house. He had run a business for 30 years. He had filed his own taxes by hand until he was 60. "You can have a lawyer look at anything you're not sure about," I said. "You don't have to rely on Constance." He looked at me then, and his expression was something I had not seen on him before. Not quite shame, not quite fear, something in between. "I know that," he said. He changed the subject. I let him. That winter, my parents stopped mentioning Daniel and Constance's plans when I visited. It was not that the subject was forbidden. It was more that a conversational door had quietly closed. My mother seemed not to notice or not to want to. She loved her son. She loved her daughter-in-law, in the way you can love someone you don't entirely trust because the alternative is too painful to sit with. I began keeping notes. A nurse's instinct: document what you see, date it, be specific. I wrote down conversations in a small notebook I kept in my glove compartment. Dates, what was said, what was not said, the closed door in my father's study, the new filing cabinet he'd acquired in the corner of the room. I did not know what I was building toward. I was not building toward anything. I was just doing what I do when something feels wrong and I cannot see the shape of it yet. I paid attention, and I wrote it down. The second winter, my father had a recurrence. Stage 3 this time. Different treatment. Longer, harder. He was in and out of the hospital from November through March, and I adjusted my shifts at Memorial so I could be with him as much as possible, mornings usually, before my afternoon rotations, and on my days off entirely. My mother was there constantly. She had the particular endurance of a woman who has decided that this is simply what is required and is not interested in being admired for it. Daniel and Constance visited twice. The visits were warm and organized and correct. Constance brought a printed care schedule. She talked to the oncologist in a brisk, informed way that the oncologist seemed to find useful. On the second visit, while my mother and father were resting, I found Constance in my father's study. She was not rifling through things. She was standing at the filing cabinet with one drawer partially open, reading something. When I came in, she closed the drawer and turned with the specific smoothness of someone who had prepared for the possibility of being walked in on. "Just checking his insurance documents," she said. "He asked me to." I looked at the filing cabinet. "Which drawer?" She smiled at me. It was the smile of a woman who had decided I was not a threat. "The one on the left," she said, and walked past me out of the study. I stood in my father's study for a long time after she left. I looked at the filing cabinet. I looked at the floor-to-ceiling shelves, the mystery novels spine inward, the framed photo of the house being framed in 1987, my father 20-odd years old, squinting in the summer light, carpenter's pencil behind his ear. I did not open the cabinet that day. My father was 40 feet away in his bedroom, and I did not want to go through his things without his knowledge. I closed the study door and went back down the hall. That was a Thursday in February. On the following Tuesday, while my mother was at the hospital and I was covering the house, my father called me into the study. He was out of the hospital for a 3-day break between treatment cycles, thinner, tired, but alert. He moved with care, the way people move when their bodies have become something they have to negotiate with rather than inhabit. He sat in his desk chair. He looked at the filing cabinet. He looked at me. "There's something I need to give you," he said. He opened the bottom drawer of the filing cabinet, not the one Constance had been looking in, which was the top left, but the bottom right, which was locked with a small brass key he took from under the pencil tray in the center drawer of his desk. I noted the location of that key without meaning to. Nurse. The drawer contained a single manila folder, thick, held shut with a rubber band. He placed it on the desk between us and sat back in his chair, as though the act of retrieving it had used something he didn't have much of. "I want you to look at this," he said. "Don't take it today, just look at it." Inside the folder was the original property deed for 4112 Delancey Street. The house, the lot, the address I had been giving as a reference point for my entire adult life. The deed was dated 1987, the year the house was completed, and it bore my father's name and my mother's name, jointly, as the registered owners. Behind it was a second document. The second document was a copy of a deed transfer, a quitclaim deed, dated 14 months earlier. April of the second year of my father's first illness. The April Saturday when Daniel had been at the kitchen table with the folder and the pens. My father's signature was on it. My mother's signature was on it. The names on the receiving end were Daniel Marcus Calloway and Constance Ann Calloway. I read it twice. I read it a third time. I turned it over as though there might be something on the back. "Dad," I said. "I know," he said. "This transfers the house." "Yes." "To Daniel and Constance." "Yes." I put the document down on the desk. My hands were very steady. I have steady hands. It's what makes me a good nurse and what sometimes worries people who don't know me well, because steady hands in a crisis can look like not caring. "Did you understand what you were signing?" I asked. I kept my voice level. He was quiet for a moment. "I understood some of it," he said. "Daniel told me it was he used the phrase co-stewardship arrangement, that it would protect the house in case something happened to me or your mother, that it was the kind of thing families do." He paused. Constance explained the paperwork. She was very thorough. "And Mom?" "She signed what I signed." He looked at the window. "Your mother trusts your brother." I looked at the quitclaim deed again. The date, the signatures, the precise, professional language of a document that had been drafted with care. "This transfers ownership," I said. "This isn't a co-stewardship arrangement. This transfers the title." "I know that now." "When did you figure it out?" He took a long breath. "A few months after, I asked Earl Whitfield. You remember Earl? I asked him to look at it. He's not a lawyer, but he's dealt with enough property in his life to know what a deed transfer looks like." He looked at his hands. He told me. "Why didn't you say anything?" "I didn't want to start a war," he said quietly. "Daniel's my son. Constance is his wife. I thought maybe it was what it was and we could all manage it together like adults." He paused. "Then I got sick again, and I thought if I started a fight and something happened to me before it was settled." He stopped. "It would be harder to fight without you." "Yes." I sat with that for a moment. "So you made a copy of the original deed," I said, "before the transfer." I'd had it in the bottom drawer for years. When Earl told me what that document meant, I thought someone else should have a copy, someone who would know what to do with it. He looked at me then, really looked at me, the way he had when I was a child, and he was telling me something important. "I'm giving it to you," he said, "not to start a fight today, just to have." I took the folder home that evening. I drove the 12 minutes from Delancey Street to my apartment, and I sat at my kitchen table for a long time. Then I got up, and I put the folder in the back of the closet in my bedroom, behind a box of winter clothes, and I did not mention it to anyone. I kept notes, as I always did. I wrote, "Tuesday, Dad showed me the quitclaim deed. April of last year. Transferred to D&C, he didn't understand what he signed. Earl W. confirmed. Copy of original deed, I have it." I put the notebook in my glove compartment. I went to work the next morning. I said nothing. I was 34 years old. I had a folder in my closet and a notebook in my car, and I did not yet know what I was going to do about either of them. My father came home from treatment in March. He was weaker than he'd been after the first course, weight down, some neuropathy in his hands, a fatigue that was different in quality from ordinary tiredness, deeper and more structural. He adapted to it with the stubbornness that had always been his defining characteristic. He was slower, but he was present. He was still reading. He still had opinions about Deuteronomy. I made a decision, in those first weeks after he came home, to wait. Not forever. I am not a person who waits forever, but until he was stable, until my mother had settled back into something resembling her routine, until I could think clearly about what the right move was. I also started researching. A nurse does not have the specific training of a lawyer, but I had the skills adjacent to it. I knew how to read a technical document, how to identify what was significant in language that was designed to obscure significance, how to trace a process from a given point back to its origin. I spent my off hours reading about property law in Georgia, about quitclaim deeds, about what made them valid and what made them contestable. What I found was not encouraging in the short term. A quitclaim deed, once signed and recorded, is a legal instrument. It can be challenged, but the grounds for challenge are specific: undue influence, lack of capacity at the time of signing, fraud, or coercion. The challenge has to be mounted within a certain window. Evidence has to be substantive. What I had was a copy of the original deed and my father's verbal account of what Daniel had told him the document was. That was not nothing, but it was also not enough, not by itself. I needed to find an attorney. I needed to do it without alerting Daniel or Constance. And I needed to do it without my father knowing, because I was not yet sure what knowing would do to him in his current state. And a nurse learns very early that you do not introduce a stressor to a patient who does not yet have the reserves to manage it. I called 3 law offices in Savannah in March. The first 2 had standard estate and property practices, but neither attorney I spoke with inspired confidence. One was dismissive in a way that felt rehearsed. The other wanted a large retainer up front before he'd even assessed the merits of the case. The third office was a firm called Holloway & Pierce on Bull Street. The attorney who took my call was a woman named Adrienne Holloway, 52, who had spent 15 years in real estate law before starting her own firm. She had a flat, specific way of speaking that I recognized from the best physicians I worked with, the kind of precision that means a person has stopped performing confidence and is simply inhabiting it. I met with her on a Wednesday afternoon in April, a year after the quitclaim deed had been filed. I brought the folder. I laid out what I knew. I watched her read the documents. She was quiet for a long time. "This is a quitclaim deed," she said, which I already knew. "Yes." "Witnessed and notarized." "Yes, Constance notarized it herself. She has a notary license." Adrienne looked up. She notarized a deed that transferred property into her own name. "Yes." In Georgia, a notary is prohibited from notarizing a document in which they have a direct financial or legal interest, she said. That's not just an ethical violation. That potentially voids the notarization. I felt something in my chest shift, a kind of precise, physical rearrangement. And without valid notarization, I said. The deed may be unenforceable, she said. It depends on additional factors. Your father's capacity at the time, whether the description of the document was accurate, whether there was coercion. She looked at the deed again. But this is a significant procedural flaw. This is where we start. I left Adrian Holloway's office on Bull Street in the early afternoon. The day was warm and the air smelled like the Savannah River, the particular salted, ancient smell of it. I sat on a bench outside her building for a few minutes. I did not cry. I texted my mother to say I'd stop by later and bring dinner. Then I went back to my car, opened my notebook and wrote, Adrian Holloway, Holloway and Pierce, Bull Street. Constance notarized her own deed transfer. Void in Georgia. This is where we start. I called Daniel that evening before dinner. I called him the way I would call a person I had no information about, a brother I was simply checking in with. We talked about my father's recovery. We talked about the weather in Alpharetta. He asked about my shifts. He was, as always, pleasant and contained, and about 2 centimeters distant. I did not mention the deed. I did not mention Adrian Holloway. I said goodnight, and I meant it, and I hung up and sat in my car in my parents' driveway for 3 minutes before going in. I needed more than the notarization flaw. Adrian had been clear. It was a significant procedural problem, but a skilled opposing attorney would argue that the deed was still substantially valid, that the error was technical rather than substantive, that it could be re-executed. We needed to establish undue influence. We needed to document a pattern. We needed, ideally, another witness. I thought about who that might be. Ruth Elaine Tremblay had lived directly across the street from my parents for 22 years. She was 68, retired from the Savannah public school system, where she had been a 5th-grade teacher, recently widowed, and possessed of the specific observational acuity that comes from decades of managing 28 children at once. She noticed things. She remembered them. And she had, as she once told my mother, a great deal of time now to sit on her porch and watch the neighborhood proceed. I had known Ruth my entire life. She had watched me and Daniel grow up. She had brought food when my father was in treatment the first time and again the second time. She was the kind of neighbor who still existed on Delancey Street, not intrusive, not absent, simply present in the way of someone who understood that a neighborhood was a living thing and required maintenance. I went to see her on a Sunday afternoon in May, 6 weeks after my first meeting with Adrian. I brought coffee and I was honest with her. I told her that I was looking into some concerns about the house and that I needed to ask her some questions. I told her she was not obligated to answer any of them. She looked at me across her kitchen table with the expression of a woman who has been waiting for someone to ask. I've been watching that house for 22 years, she said, and I have wondered more than once whether anyone was ever going to ask me what I've seen. What Ruth had seen over the preceding 2 years was this. Daniel and Constance had visited the house on at least 4 occasions that Ruth could specifically identify when my mother was not at home. She knew my mother's Thursday schedule, book club, then errands, then home by 2, and the visits she remembered had all occurred during that window. She had noted this because, the second time it happened, she had thought it unusual enough to mention to her late husband, who had agreed that it was unusual. On one of those occasions, she had seen Constance carry a box of documents into the house and leave with a different box. This had been in February of the first treatment year, several months before the quitclaim deed was dated, but during the period when, as my father had told me, Constance had been helping with paperwork. Ruth had also, on one occasion, heard raised voices from inside the house. She was specific about this. She had been collecting her mail and had heard, through the open front window, my father's voice at an unusual volume, not what she would call shouting, but elevated in a way she had never heard from him before. And then, shortly after, Constance's voice, lower, steady, which she described as the voice of someone making a point calmly to someone who is upset. She had gone back inside her own house because it was not her business. She told me this with precision. She had not mentioned it to anyone because no one had asked. "Would you be willing to say this to an attorney?" I asked. She looked at me steadily. "Is that what this is coming to?" "I think it might be." She nodded once slowly, the way she might nod when a student had finally answered a question correctly. "Yes," she said, "I would." I drove back across the street. I sat in my car outside my parents' house, and I looked at the front window Ruth had described. The light was on in the front room. Through the glass, I could see the edge of my father's chair, the corner of the bookshelf he'd built in 1991 when the living room collection had outgrown the study. I texted Adrian. I said, "I have a witness. Can we meet this week?" She replied within 10 minutes. "Thursday morning, 9 a.m. Bring everything. There is a day I need to tell you about." It was a Saturday in August, 2 months before my father's final hospitalization. He was still at home, still managing. He had reached a point the oncologist described as a plateau, which meant not worsening but also not improving, a suspended state that could persist for months or could change quickly. He had good days and difficult days, and this particular Saturday was a good one. I arrived at the house around 10 in the morning to find him in the back garden, which he had managed to maintain at about a third of its former ambition. A strip of tomatoes, some herbs in pots, the rose bush my mother had planted in 1998 that required nothing from him except occasional authority over its direction. He was moving through the garden with the careful attention of someone who has learned to work within limits. And he looked, I want to get this right, he looked occupied. In the best sense of that word. We spent the afternoon the way we sometimes did in that period, slowly, without agenda. I made lunch. He ate more than usual. We sat on the porch and he told me, in the discursive, unhurried way of someone who knows they have a limited number of afternoons in which to say things, about the summer he built the house. He had not talked about it in years. He told me about Earl Whitfield, who had been dead since 2015, and what Earl had taught him about reading a level, and how he had made a specific error with the framing of the study window that Earl had caught and helped him correct without making him feel foolish. "That's a good way to teach someone," I said. "It's the only good way," he said. "Show people how to fix the thing without showing them where to put the shame." I thought about that for a long time after. He asked me, toward the end of the afternoon, whether I had done anything with the folder he had given me. I told him I was working on it. He nodded. He did not ask what that meant. He trusted me to know what it meant, which was, in the specific language of our family, a form of profound confidence. "I'm sorry," he said after a moment, "that I waited so long to say something, that I let it get." He stopped. "I didn't want it to be true. I kept thinking Daniel would." He stopped again. "I know," I said. He looked at the garden. "He's still my son." "I know that too." We sat for a while in the particular quiet of a late summer afternoon, the kind that is full of sound, the heat insects, the neighbor's sprinkler, the distant movement of the city, but still feels like silence. He reached over and put his hand on mine for a moment. A brief gesture, my father's version of a declaration. Then he took his hand back and said he thought he'd go in and rest before dinner, and I said I'd stay and start something, and we went inside and the afternoon folded shut behind us. I think about that afternoon often. It is the one I return to when things become difficult, the one I hold up as the reason the rest of it mattered. My father died on a Thursday morning in October. I will not describe the details of his final hospitalization because they are private, and because this is not that story belongs to my family and no one else. What I will tell you is that he was not alone. My mother was there. I was there. He was, as far as we could judge, not afraid. Daniel and Constance arrived the afternoon of the funeral. They had been notified when he was admitted. I called Daniel myself, which I note only because it matters later. They arrived 12 days into a hospitalization that none of us had expected to end that way. The week after the funeral was dense and quiet and strange. The way grief weeks always are full of food people bring and logistics no one is prepared to manage, and a specific tiredness that is different from ordinary tiredness, the kind that comes from carrying something that has no form. My mother was, outwardly, steady. She had the same quality my father had, not the same volume, but the same core. She was a woman who understood that things required doing, and that doing them was not the same as being fine. Daniel and Constance stayed through the following weekend. The house was, during that period, full in the way houses are after a death. Neighbors stopping by, church friends, my father's former business partner George Tillman, who cried openly and without apology, Earl Whitfield's daughter who I had not seen in years. On the Monday morning after the funeral, 4 days after my father died, I came downstairs at 7 to find Constance at the kitchen table with a folder of documents. My mother was not yet up. Constance looked up when I came in. She was composed. She had the quality, that morning, of someone who had decided the waiting period was over. "There are some things we need to go through," she said. Now that, she didn't finish the sentence. She did not need to. "What things?" I said. "The house, going forward." She opened the folder. "Daniel and I have been thinking about what makes the most sense. We want to support Mom, obviously. But the practical reality is that the property is now registered to us, and we need to have a conversation about what happens next." I looked at the folder. I looked at her face. "I'm happy to have that conversation," I said, "but not without a lawyer present." Something shifted in her expression, a small adjustment, like a camera refocusing. She had not expected that sentence. "That seems like an overreaction," she said. "We're family. I'd still like a lawyer present." She looked at me for a moment longer, then closed the folder with a motion that was controlled and precise. "Of course," she said, "whenever you're ready." I went upstairs and called Adrian from my childhood bedroom. Sitting on the edge of the bed I had slept in from age 7 to 18, looking at the poster of the Georgia coast I had put up at 14 and never taken down. "It's starting," I told her. "I know," she said. "I've been expecting this call." "Tell me exactly what she said." The conversation with Constance in the kitchen was the first one. There were 4 more in the following weeks, each one slightly more direct, each one moving in a clear direction. The clearest came 5 weeks after the funeral. I arrived at the house on a Saturday to find Daniel in the kitchen, not Constance, Daniel. He was standing at the counter, and he looked, for the first time in years, like my brother. Not the real estate version, not the Sunday call version. He looked tired. He looked like a man who was doing something he had been assigned to do and had not fully chosen. "We need to talk about the house," he said. "Yes," I said. "Mom can stay," he said. We want to be clear, we're not asking her to leave. We thought maybe she'd want to downsize eventually, but—" "Daniel," I said. He stopped. "Did you know," I said, "that in Georgia, a notary cannot notarize a document in which they have a direct legal interest?" He looked at me. Something moved behind his eyes. "Constance notarized the quitclaim deed," I said. "The deed that transferred this house. She notarized a document that put the property in her own name." I paused. "I have an attorney. Her name is Adrienne Holloway. I'd like you to have your attorney call her." Daniel's jaw tightened. He looked at the counter. He looked like a man doing calculations. "You've been planning this," he said. "I've been preparing," I said. "There's a difference. We had Dad's signature." "You had his signature on a document he was told was a care authorization. I have him on record explaining what he was told that document was. I have a witness who saw the visits to this house when Mom wasn't here. And I have the original deed, which predates your transfer, which is still in my possession." I looked at him steadily. "Call your attorney, Daniel." I turned and went upstairs. My hands were steady, they always are. "I want to tell you about the moment I decided not to stop." There is a version of this story, I have seen it play out with families at the hospital, and in the accounts of people I know, where the person who has been wronged makes it to the edge of the fight and then stops. Not because they don't have grounds, not because they lack evidence, but because the cost of proceeding is a cost paid in family, in the relationship with the sibling, in the mother's peace, in the daily livability of every holiday and Sunday call going forward. I have watched people make that calculation and choose to stop. I have never judged them for it. I am telling you my particular story, not a universal one. My father had handed me that folder in his study on a Tuesday in February, 2 years before he died. He had looked at me with the eyes of a man who was out of options, and was placing his trust in the one person in his life who he knew would be steady. He had said, "I'm giving it to you, just to have." He had not said, "Fight for it." He had not said, "Take this to court." He had simply given me a document and trusted me to know what to do. My mother had lived in that house for 37 years. She had stood at that kitchen window every morning of her adult life. She had planted the rose bush in 1998, and the herb garden in 2003, and the lavender border along the front walk in 2011. The house was not an asset to her. It was the shape of her life. Constance wanted to have a conversation about my mother, potentially downsizing. I called Adrienne and told her we were proceeding. She had been ready since April. We spent 2 weeks building the case file. The original deed, the quitclaim with Constance's notarization, my father's account of what he had been told when he signed, which Adrienne had taken in a recorded conversation 6 months earlier during one of his better days, with his full knowledge and consent, Ruth Tremblay's written statement, my own documented timeline. Adrienne also ordered a title search of the property records for Chatham County, which revealed that the quitclaim deed had been filed within 72 hours of the document being signed. Faster than was standard for a legitimate transfer, faster in a way that suggested urgency. They wanted it recorded before anyone could look at it, Adrienne said. Before my father could change his mind, I said. Oh yes. Daniel had retained an attorney in Atlanta, a property lawyer named Marcus Webb. Adrienne knew of him. She described him as competent and experienced, which she said in the tone of someone describing a chess opponent they were not afraid of. The first letter from Marcus Webb's office arrived at Adrienne's office in November, 6 weeks after the funeral. It asserted the validity of the quitclaim deed, cited my father's signature, and suggested that any challenge would be both legally baseless and disruptive to the family's healing process. That last phrase, disruptive to the family's healing process, was the one Adrienne read to me over the phone in a tone of specific contempt. They're trying to make the legal challenge itself the problem, she said. This is a standard move. They want you to feel like the bad actor for pushing back. I don't feel like the bad actor, I said. Good, she said, don't. I will not pretend the next 8 months were easy. I am a nurse. I understand the relationship between honest assessment and actual outcome, and the honest assessment was that we were in a real legal contest with real uncertainty, against an opposing attorney who had experience and resources, and a client who was not going to back down without significant pressure. What we had was a procedural flaw, the notarization that was not trivial but was not automatically decisive. We had testimony about my father's understanding of the document, but testimony is interpreted, not absolute. We had Ruth Tremblay's statement, which established a pattern of access and behavior but did not prove intent. We had the timeline of the filing, which was suggestive but not conclusive. Adrienne was systematic and unhurried. She filed a challenge to the deed with the Chatham County Superior Court in January, 8 months after my father's death, on 3 grounds: invalid notarization, undue influence, and fraudulent misrepresentation at the time of signing. Marcus Webb's office filed a response within a month. The case was scheduled for a hearing in August. In the meantime, my mother continued to live in the house on Delancey Street. This was, legally, an uncomplicated thing. There was no court order requiring her to leave, And while Daniel and Constance could theoretically have moved to force the issue, Adrian had sent a letter early in the process making clear that any such action during active litigation would be aggressively opposed. They did not push. My mother knew by this point what was happening. I had told her carefully in stages over several conversations. The first conversation was the hardest, watching her face as I explained what the April Saturday had actually been, what Daniel and Constance had done, and the hardest part of it was not her anger, which I could have managed, but her sadness. She was sad in the specific way of a person who is not surprised but had hoped not to be confirmed. He knew, she said. She meant my father. He knew and he didn't tell me. He was trying to protect you, I said. She looked at the kitchen window for a moment. That was never his best quality, she said. She was steadier than I had expected after that, with the practical steadiness she brought to things she had decided to manage rather than feel. She spoke to Adrian once, directly, and answered her questions with precision. She did not speak to Daniel for 6 weeks. Daniel called me twice during that period. The first call was procedural, something about the paperwork. The second call was different. He called on a Sunday night. I almost didn't pick up. When I did, he was quiet for a moment before he said anything, and what he said surprised me. She told me it was a co-management document, he said. When she explained it to me, she said it kept Dad's name primary and just added us for administrative purposes. I was quiet. I didn't know it was a full transfer, he said, until the attorney showed me what it actually said. I thought about that for a long moment. I thought about the April Saturday Daniel at the kitchen table with the folder and the pens, saying it's just practical, it's just housekeeping, saying the words Constance had given him in the voice of a man delivering a script. I thought about whether he had known, and I decided I would never fully know. I thought about what my father had said. Daniel has ideas. Constance has been helpful. I believe you, I said, which was partially true and the truest I could be at that moment. Miriam. Call your attorney, Daniel, I said, as gently as I could. That's where this has to be resolved now. The near-quit moment came in May. Adrian called me on a Thursday evening to say that Marcus Webb had filed a supplementary brief that raised a new argument, that my father's recorded conversation, given his health status at the time of recording, could be challenged on grounds of cognitive impairment, which would undermine the undue influence testimony. Can they make that argument stick? I asked. We can counter it, she said, but it'll require medical testimony from someone who treated him. I was quiet. I know what I'm asking, she said. I thought about my father's oncologist. I thought about the conversations I had been in when his cognition was assessed. I thought about the particular clarity of him in that recorded conversation, careful, deliberate, choosing his words with the precision of a man who knew his words were going to matter. I'll make some calls, I said. I made the calls on Friday. By the following Tuesday, I had a commitment from Dr. Anita Chundran at Memorial, who had treated my father through both treatment cycles and who had documented his cognitive status at every step, to provide a written declaration of his capacity at the time of the recorded statement. She was specific and categorical. My father had been alert, oriented, and fully communicative at the time of the recording. Marcus Webb's supplementary brief went nowhere. In July, 3 weeks before the hearing, Constance's notary commission records were subpoenaed. They confirmed what Adrian had asserted. She had notarized the quitclaim deed while having a direct legal interest in the document, in violation of Georgia Code Section 45178. The hearing was scheduled for August 14th. I took the day off work. Chatham County Superior Court is on Montgomery Street, a 10-minute drive from Delancey Street. I had driven past it hundreds of times. It is part of the city the way all civic buildings in Savannah become part of the texture of daily life, familiar and unexamined. I had never been inside. I arrived at 8:45 for a 9:30 hearing. Adrian was already there, at a table with 2 file boxes and a printed brief that I knew ran to 47 pages because she had walked me through it the week before. She was wearing the gray suit I had come to associate with her in formal settings. She looked at me over her glasses and gave me a single nod, which from Adrian was the equivalent of a long speech. My mother sat beside me in the gallery. She had dressed in the careful way she dressed for church, not somber, not performative, simply correct. She held her purse in her lap with both hands. Ruth Tremblay was there. She had driven herself. Daniel and Constance arrived together and took seats at the opposing table with Marcus Webb, who was tall, silver-haired, and carried himself with the practiced ease of a man accustomed to the specific acoustics of courtrooms. Constance was dressed in a business suit. She looked prepared. She and I made eye contact once briefly as they entered. She looked away first. The hearing was not dramatic in the way courtroom scenes in films are dramatic. It was procedural and precise, and moved with the particular unhurried rhythm of a legal process that has been carefully prepared on both sides. Adrian made her argument methodically: the notarization violation, the documented misrepresentation, my father's recorded testimony, Ruth's statement, the title search timeline. Marcus Webb countered on each point with the arguments we had anticipated. The moment that mattered came when the judge, a woman named Honorable Diane Aikson, asked Marcus Webb a direct question about the notarization. "Counsel, your brief suggests the notarization defect is merely technical," she said. "Can you point me to any Georgia precedent in which a property deed was sustained where the notary held a direct ownership interest in the transferred property?" There was a pause. "We believe the substantial validity of the instrument," Marcus Webb began. "I didn't ask about substantial validity," Judge Aikson said, in a tone that was not unkind but was absolutely final. "I asked for precedent." There was a longer pause. "We're not aware of controlling precedent on that specific point," he said. She looked at her documents for a moment, then she looked up. The ruling took 4 minutes to deliver. Judge Aikson found the quitclaim deed invalid on the grounds of the notarization violation, citing the specific Georgia statute Adrian had identified. She also noted, in language that was precise and did not require elaboration, that the court found the account of the circumstances surrounding the signing, including the misrepresentation of the document's nature and the speed of filing, troubling. She ordered the title to 4112 Delancey Street restored to its registered owners prior to the invalid transfer, Curtis Calloway and Patricia Calloway. As my father was deceased, the property would pass to my mother as the surviving registered owner per the terms of their joint ownership. She struck the gavel. Adrian put her pen down and looked at her notepad for a moment. My mother made a small sound beside me. I reached over and put my hand over hers. Ruth Tremblay, 3 rows back, said nothing. But when I turned around to look at her, she gave me one decisive nod, the same nod she had given me at her kitchen table 6 months earlier. The nod of a woman who had answered a question correctly and known she would. I looked at the table where Daniel and Constance were sitting. Constance was looking at the surface of the table. Daniel was looking at me. I could not read his expression. I have thought about it many times since. It was not anger. It was not defiance. It was something more private and more difficult, the face of a person who had arrived somewhere they had not entirely chosen and could not entirely account for. I held his gaze for a moment, then I looked away. The practical aftermath of the ruling took about 3 months to fully resolve title restoration paperwork, notifications to the county records office, the various administrative processes that follow a legal change of ownership. Adrian managed all of it with the same flat efficiency she had brought to every stage of the process. By November, the title to 4112 Delancey Street was registered in my mother's name alone. My mother went back to her Thursday book club the week after the hearing. She stood at her kitchen window on the Friday morning. She had never left, she had been in the house throughout the legal process. But she told me, on that Friday, that something felt different about standing there now. She used the word settled. She said the house felt settled. I understood what she meant. Daniel called me in September. It was a Sunday, which was his calling day, and I answered because I always answer. He did not mention the ruling directly. We have a family habit of not naming the largest things in any given room, but he asked about my mother, specifically and carefully, in the way of a person who is performing a return to the ordinary and hoping the other person will let them. I let him. Not because everything was resolved. It is not, and may never fully be. But because he is my brother, and because the resolution of a legal dispute is not the same as the resolution of a family, and I do not expect the two to move at the same pace. Constance called once. I did not pick up. She left a voicemail that I have not deleted but have not listened to more than once. I will leave it at that. The question I get asked, in various ways, when people learn this story, is whether I think Daniel knew what Constance had done. I have thought about this more than anything else in the entire 2-year period. More than the deed, more than the hearing, more than the ruling. My honest answer is, I believe he knew some of it and understood less of it than she did, and I believe he told himself the story she gave him because it was easier than the alternative. I do not think this makes him innocent. I do not think it makes him fully culpable either. I think it makes him a man who chose not to look too closely at something that benefited him, and who is now living with what that choice cost. That is not a rare thing. That is, in fact, one of the most ordinary failures a person can have. It does not excuse it. It also does not surprise me. My mother does not speak to Constance. She speaks to Daniel on the phone, with the particular warmth she has always brought to her son, and the particular reserve she brings to things she cannot fix. He visited at Christmas. It was quiet and it was present, and it was not what it used to be. Those things can both be true. I worked through most of it, in the way nurses work through things, not by not feeling them, but by having the feeling at the edge of a shift, or in the car, or at the end of a long Tuesday, and then returning to the work. The work helps. It always has. Adrienne Holloway sent me a bottle of wine after the ruling. I called her to thank her, and she said, in her flat, precise way, that it had been a good case, and that it was exactly the kind of case the statute was designed for. I think that was her version of warmth, and I appreciated it. Ruth Tremblay came for dinner in October, the month after the hearing. My mother made her pot roast, which is the meal she makes for people who have earned it. We sat on the porch after, the three of us, in the late-season warmth of a Savannah autumn. Ruth told us a story about something one of her former students had done, and we laughed, and it was the uncomplicated kind of evening that makes you aware, precisely because of its simplicity, of what has been at stake all along. There is something in my mother's study. She has taken over my father's study, which is a thing I did not entirely expect, and that made me cry the first time I noticed it, quietly, in the car afterward. There is something in the study that I want to tell you about. She has kept his bookshelves as they are. His books, his arrangement, the mystery novels still spine inward in the way that was specifically him. She has added, on the bottom shelf, her own books, the ones from her book club years, the gardening references, the Bible she's had since 1975 with the annotations in the margins in her careful round handwriting. His desk chair is still there. She sits in it to read. On the wall where the photo of the framing of the house used to be my father at 20-odd, squinting in the summer light, she has put a second photo beside it. The first is the same one, him with the carpenter's pencil behind his ear in 1987. The second is from our last Thanksgiving together, my father and my mother on the porch he built, late afternoon light, my father with his arm around her shoulders. He is thin from the treatment. He is wearing his good shirt. He is looking at the camera with the expression of a man who knows what he has. She framed them the same way, the two photos, side by side. I have the folder in my closet still. The original deed, the copy of the quitclaim, my notes. I have not thrown it away. I don't think I will. It is not a trophy, that is not what it feels like to have it. It is more like what my father said about the house itself. that walls absorb time, that things hold the weight of what happened in them. The folder holds 2 years of patience, and a Tuesday afternoon in February when my father sat in his desk chair and trusted me with something he could not manage alone, and my own particular brand of stillness in the face of things that want to frighten you. I kept it, I keep it. And the house is still standing on Delancey Street, the way it has been standing since 1989, when the final coat of paint went on, and my father stood back and looked at it for a long time without saying anything, the way he was when something had been done right. It is still standing. If you've stayed with me to the end of this, then you already understand something that I didn't fully understand when I was in the middle of it, that the hardest part of this kind of fight is not the legal process. It's not the documents, or the hearing, or the waiting. The hardest part is the moment when you have to decide whether the fight is worth what it costs, because it will cost something. It will cost peace, for a period. It will cost the version of your family you were hoping to keep. It will cost you sleep, and holidays, and the easy phone calls that used to be easy. What I can tell you is this: the version of your family you were hoping to keep may not be the one that was actually there. And the fight, when it is over, is not the thing you carry. The thing you carry is the choice, the fact that you made it, that you were steady, that when the moment came, you did not look away. My father built a house with his hands because he believed that what you build should stand. He also believed that if something you built was taken from you under false pretenses, you had not only the right but the obligation to go and get it back. He was right about both things. If something has been taken from you, a home, a right, a name on a document that was always supposed to have your name on it, and you are wondering whether to fight, I am not going to tell you what to decide. It is your decision and no one else's. But I will tell you, get the documents. Write down what you know. Find someone who understands the law in your state or your country and ask them what you're looking at. Don't wait. And if you are in this right now, if you recognize something in this story, if you have been sitting with a piece of paper or a memory or a question you have been afraid to ask, leave it in the comments. I read every single one. You may not be as alone in this as you think. If this story reached you, share it with someone who needs it. Hit subscribe for a new story every week. And take care of yourself. That is all I have.